the Folgers, good to the last drop. You have this commercial where this son comes home from a leave from the military. He's in the kitchen. He's brewing a cup of coffee. His mother comes in. There's a heartwarming scene. They hug. Folgers, good to the last drop. That whole image and all of that, you can smell the coffee as you're watching the commercial. It all sinks in and it anchors in your mind this idea that Folgers coffee is good and it's good to the last drop. Or O.J. Simpson's trial, if the glove doesn't fit, you must acquit. It's just this concept of creating sort of a sentiment or a decision around something that's solid, and you anchor it to it. Now,
trucking is difficult. It's an essential industry that every corner of the nation depends on, even without knowing it. To the average consumer, the supply chain is magic, and sometimes a black hole. Products on store shelves, dinner on restaurant tables, packages on doorsteps. It's expected to be there on time, every time, and only recognized if there's a service failure. But how is a sausage made? Who's talking about the issues that matter to trucking companies?
Welcome to True North Truck Thought, or the TTT Pod for short, a monthly podcast hosted by Scopolitas Transportation Consulting and brought to you by True North Companies. We're here to demystify the magic, address the black holes, and to talk trucking to the industry we love. Whether it's the latest research, upcoming laws and rules, safety issues and solutions, or practical discussions about real-life supply chain challenges, the TTT Pod is here to help the most important industry in our country to navigate its greatest challenges and opportunities. We bring together some of the best and brightest experts to talk about and tackle some of the most pressing industry issues. So without further ado, I'm Steve Kepler.
And I'm Sean Garney. Let's get trucking. Welcome back to the TTT Pod. Today we're tackling a crisis that's driving up costs, shutting down businesses, and putting the future of trucking at risk. And that's lawsuit abuse and the rise of nuclear verdicts. In recent years, we've seen jury awards in the hundreds of millions and even billions of dollars, often far exceeding the actual damages. These verdicts are driving skyrocketing insurance premiums, forcing small and mid-sized carriers out of business, and creating an environment where frivolous lawsuits are a constant threat. But the industry isn't taking this lying down. States like Texas, Florida, Iowa, and most recently Arkansas have taken action with tort reform measures aimed at restoring fairness in the courtroom, while groups like the American Trucking Associations continue to push for broader reforms to stop these excessive awards. Joining us today is Pam Bracher, Deputy General Counsel for the American Trucking Associations, who's been on the front lines of these efforts. We'll be discussing key drivers behind nuclear verdicts, the impacts they're having on motor carriers across the country, and, more importantly, what the industry can do to fight back. Unlike many, she's been tracking defense victories over the last several years and has been working to chart our path to victory. Also joining us from the True North team is Peter Berg, Principal and Practice Leader. If you're a fleet owner, safety manager, or anyone invested in the future of trucking, I think this is a conversation you're not going to want to miss. Pam, Peter, Steve, as always, thank you for joining us today. We appreciate your time. Pam, before we get started, maybe we can just do a little bit of introduction. You can give us your 30-second elevator speech. Maybe we can hear from Peter, and then we'll dive right into the old conversation.
Well, thank you for having me today. The 30-second elevator speech is that I'm an attorney of 27 years, about 7 years in private practice with a law firm in Chattanooga as a defense trial attorney, and 20 years in-house at 2 trucking companies, defending those trucking companies and our truck drivers in crash, personal injury, wrongful death litigation.
That's a long pedigree of fighting the good fight here, I think, for sure. Peter, can you match that, or how you gonna respond?
I will try, and thank you for having me. It's a pleasure to be here and in my inaugural podcast. Peter Berg, Principal and Practice Leader at True North. I've been here for 18 years. In transportation and logistics, helping large motor carriers and freight brokers and freight forwarders think about holistic enterprise risk management. That includes the proactive strategies we use to put our motor carrier clients and transportation clients in the best possible position if and when these claims come forward, and also designing strategies that react to, with a risk transfer and insurance perspective, react to these claims to make sure that they're still made whole and can indemnify the various parties. So working on both sides of the conversation.
Fantastic. Well, thanks, Pam and Peter. We really appreciate y'all joining us today. And as Sean said, seems to be an ever-growing challenge in our industry. Maybe, Pam, you could start with you. Start kind of how do we get here? Maybe give us a little historical perspective on how nuclear verdicts have become such a big issue in the industry.
So I'll start right off the bat by saying that I'm not a big fan of the nuclear verdict terminology, and I know we can talk about that later. But to answer your specific question, I think the shift really happened around 2008, 2009, 2010. That's when you started to see settlement creep, in my experience. There was a lot of tort reform, especially in the med-mal space, that happened in the 1980s and the 1990s, and so the residual effect of that tort reform, again in the med-mal space, was that there were some steep malpractice increases. Tort reform came into med-mal, and plaintiffs' attorneys that had been successful making good livings for themselves, suing doctors in medical malpractice, had to shift away from med-mal. And they started exploring other avenues in the personal injury and wrongful death space, and that happened in the early 2000s. About that same time, you started to see a shift in the plaintiff's bar where they were experimenting more so than ever with how they can leverage human psychology. And the first big example that we saw was the publication in 2009 of the manual, the reptile, the 2009 Manual of the Plaintiff Revolution, and that was published in 2009. Don Keenan and David Ball published that book, and Don Keenan is a trial lawyer, but what people forget is the pedigree of David Ball. David Ball had a BA in English, an MA in English, and a PhD in speech communication and theater arts. So he adapted theater and film techniques to trial strategy. He's a professional storyteller.
Yeah.
And so that's the beginning of when the plaintiff's attorneys really started using human psychology and how to tell a story. And I think it is at that point, especially when they were starting to find new defendants to sue, because tort reform and med-mal had been so successful, that you started to see the settlement creep and the verdict creep. And where we lag behind is I'm a defense attorney. I am through and through. I could not be a plaintiff's attorney. I have many friends that are plaintiff's attorneys. Not all of them are bad. Some of them are good. But where we lag behind is the plaintiff's attorneys are getting together and they're constantly learning. And I don't mean comparing notes about the companies. I'm saying they're constantly learning how to tell a story. They are not so prideful that they don't think that they can't learn a new technique of conveying their message. Defense attorneys get together, but their continuing legal education isn't the same continuing legal education that the plaintiff's attorneys are doing. And more importantly, when the defense attorneys are getting together, they're usually inviting their clients and using it as a client retention tool or a client development tool. Plaintiff's attorneys not bringing their clients around. They truly are getting together and they are saying, hey, here's this new strategy. They read books, and it's not just on trial strategy. It's sometimes, business books. But they're learning new tricks, is my point.
Well, I checked this morning. You mentioned the reptile theory. It's on sale on Amazon today for $1,680. So
actually, you should get that. That's cheaper.
Well,
than
you
the last
don't
time I
have
checked.
to buy the books, and maybe you can find it in McKay's for a lot cheaper. But there is now a cottage industry around seminars that teach essentially what that theory is, which is really junk science and more linguistic than anything truly scientific. But the point that I wanted to make is the background of David Ball, because that is really key to understanding how the shift occurred.
it was interesting just to hear about the collective of plaintiffs' attorneys and how well they sort of work together to learn new things. And to me, like, very interesting to learn this from somebody from the American Trucking Associations, who's part of their charge is, of course, to get people together to help educate. Why do you, I mean, you mentioned some of the reasons why defense attorneys maybe didn't have that same sort of collective thought because they were using it for other purposes. Do you see that changing? Is that something that we're getting better at as defense attorneys?
I think defense attorneys are better at collaborating and sharing information about particular venues, judges, plaintiffs' attorneys, sharing trial transcripts, deposition transcripts, motions practice. Are they perfect? No. They have room for improvement. They can become better at it. But I still don't think that they are practicing their craft and thinking about their craft and maybe, reading some of those soft skill books. And I remember when I started as a defense attorney, I went to a trial academy right out of in my early years as an associate. And it's pretty common for a lot of defense firms to send their associates to trial academies. And it's like a week-long intensive, and you really, you really kind of take a case and you mock it, but it's the expectations are high. That's the one, I've been doing this for 27 years. I did it one time. And I don't know that defense attorneys, we can get into a lot of it, like just the economics of how the defense, how you pay a defense attorney versus the economics of a plaintiff's attorney. There's lots of different drivers, there's different things happening there, but I don't know that, and defense attorneys also are a little bit more conservative for a lot of reasons, but I don't know that defense attorneys necessarily think about or are incentivized in the same way that plaintiffs' attorneys are to practice their craft, to hone their skills, and really become a natural storyteller.
Interesting. So what have you seen? Have there been any like legal or regulatory changes of late?
Oh, for sure. Yeah. So what's happened is, since in 2019, the ATA launched its tort reform effort, which we call the lawsuit abuse reform now. It's the same terminology. And, we have several strategic priorities that we focus on that we think will move the needle in the trucking space. And briefly, it's things like capping non-economic damages, the adoption of what is affectionately called the McAfee rule, where if a trucking company admits that the truck driver was working for them, driving at that time of the accident in course and scope, then they can't be independent causes of action like negligent hiring, training, supervision shouldn't proceed. Rules around admissibility of seatbelt non-use, getting the medical amounts paid, admitted into evidence, so you don't have this phantom damage problem where juries are hearing only what's billed or what's in a letter of protection. So those are just some of the strategic priorities. It takes different forms because of different needs at different states. But we've been working on that since 2020 and with our Federation of State Trucking Associations. And obviously we've had successes in West Virginia, Montana, Indiana, Iowa, Florida, hopefully Georgia, Texas. I'm trying to think of other states. Colorado. I mean, we've had some successes in it, but it's a slow process. It's a long game. And most of the, like, for example, the two big efforts in Iowa and Florida took at least 4 years because of just the process of lobbying and
there's a lot of education that needs reform. To happen.
Yeah, for sure.
Why do you think, so I was looking at the Chamber of Commerce, they put out their nuclear verdicts update last year, and product liability for nuclear verdicts, of all the nuclear verdicts, product liability had about 23%, auto liability had about 23%, and then medical, where you said that this sort of started, was at 20%. Why do you think trucking is getting so much play? Are we an easy target? Or is it the nature of our business, or what is it that focuses people's ire on us?
Well, I don't know that trucking is getting any more play than any other corporate defendant. So maybe that's a controversial statement, but I think that, yeah, we, I think that, again, going back, the plaintiff's bar has mastered the power of a hashtag, and right now you have, a growing segment of our population that are quite honestly populists. And the definition of a populist is someone who doesn't necessarily favor institutions in any form, government institutions, corporate institutions. So I think in general, corporate defendants are a target. Is trucking a subset within that is even more a target because, trucks are annoying and they take up a lot of space on the road? And maybe, like kind of like trains might be annoying because you get stopped at a railroad crossing when you're late for something. Absolutely. So, we're these big 18-wheelers, what is it? Large pounds in our trailer. So in that sense, we might be easy targets, but I don't necessarily think that we're any more at target than any other company,
it's more like
providing
a legal
good or
culture
a
thing
service.
almost, just like a trend across all of them.
Yeah.
That's interesting.
I
Steve's a very good driver.
Even though I'm safe. So
I do think sometimes, though, that we're our own worst enemy. And, a lot of companies might have made investments in sort of their public image or their communications with the public in general. I don't know that truckers are necessarily thinking about, how are we presenting ourselves, and, what do our forward-facing documents say? What does our webpage look like? And so sometimes I think like we're our own worst enemies, and in that sense, we're easy pickings for plaintiffs' attorneys to twist some of our own words against us.
that's a really interesting point, Pam, because I think that's, clearly you mentioned the hashtag, and the plaintiffs, but the media clearly plays a role in this too. And and so, what are your thoughts there? Kind of how is the media shaping this, and how is that contributing to the challenge we're trying to deal with here?
Well, when I was a kid, and hopefully everyone can see the gray in my hair, but when I was a kid,
I've got it too.
The
At
glory
least you've
days
got
in the-
hair, so.
Yeah, the glory days in the 70s, right? Smokey and the Bandit. Four-wheelers had CBs.
Oh, yeah.
My dad talked on them. Mm-hmm. We communicated with truck drivers, right? My dad we'd go on a family vacation to Florida, and my dad would be talking to the truckers at night.
Breaker 19, Breaker 19.
Yeah, like that was so great. I remember all through high school and college, and then in the 80s, there was like this shift. And truck drivers started being depicted in films. I remember Thelma and Louise. That truck driver in Thelma and Louise was, just didn't make the best appearance. And it doesn't help that we've had a couple of high-profile convictions of serial killers, that were truck drivers. You fast forward to the mid 2000s, and I don't know, and then you get these large verdicts, and they're very salacious, So what looks better, Wabash getting hit with a $462 million verdict, or one of the defense wins that I've listed, like Sean mentioned, that I've been keeping track for years. It just doesn't have the clickbait when, oh, look, Knight Swift won that trial. Doesn't have the same clickbait as Warner got hit with a $1 million verdict. So, and what happens is those headlines, start to normalize people that end up on juries, and in fact are anchors in and of themselves. Nobody knows what happens, as Paul Harvey would say, with the rest of the story. Nobody's going to know that the Wabash verdict has already been reduced, right? They're just remembering that first number, and it serves as an anchor, and it somehow seems normal to them that we can award that incredibly unsustainable amount of money.
Yeah, and when they see sizes like that, the public probably thinks, wow, they really did something bad, right?
Yeah.
And in fact, in often cases, it's not the case at all.
Yeah.
or it's definitely dispute. You know, it's really, this is where I have my trial hat on and I struggle. Like, just because a verdict is $14 million doesn't mean that the verdict was not the right number, if that makes any sense, because you really have to get into the facts of the case. But you're right, Steve. If I went to, I'm in Tennessee. So if I went to a meat and three right now and took a poll of all the people eating at the meat and three and said, hey, a truck is maintaining its lane, but this other car came across the center line and hit the truck head on, who's at fault for that accident? Every single one of them would say the car that crossed the center line.
Right. Man, I just love that answer. It was like a run down memory lane. We're talking about Bracher 1.9 and Paul Harvey. That was just fantastic. I think we're going to take a break here for station identification, but when we come back, I think one of the things I was most excited to talk to you, Pam, about is your disdain for the term nuclear verdict and how that's contributing to the problem. And I want to get to this point that you were talking about taking the fear out of this, because I think that's super important. So let's pause real quick, and then we'll come back and we'll digest that a little bit.
Since 2001, we've been partnering with top-tier transportation firms, building custom solutions, delivering tangible results. Our mission remains steadfast: to help transportation companies like yours in protecting and maximizing assets, resources, and opportunities.
Whether you're a motor carrier, freight broker, owner-operator, or a final mile service provider, we're here to support your unique needs.
Reach out to our team of specialists to learn more about how we can tailor a comprehensive solution to meet the needs of your business.
Great. Well, thanks. Welcome back, Pam and Peter. Really been enjoying the conversation. Want to really unpack this, the negativeness around the term nuclear verdict, and what we should do, what trucking should do about that. How should we be scared as we are? There's been so much ginning up, and every conference we've been to for the last 6 years have been telling us, to run for the hills. But it sounds like you might have a different message, so I'd love to hear that.
Yeah, so the term nuclear verdicts I'm not a fan of it, because when you say that something is nuclear, you have this image of, again, I'm from Oak Ridge, Tennessee, so we contributed to the bomb that was dropped on Hiroshima. But you have this image, of this dark, mushroom cloud coming up, and it's just this overwhelming sense of doom and gloom. And I think what it has done is and then you see these headlines, it has created this Chicken Littleism. The sky is falling. And people think every time I take a case to trial, it's going to be met with a nuclear verdict. Well, I have lots of defense wins. And I think that every time you take something to trial, and you have to be strategic about the reasons why you're taking it to trial, but I think that when you take something to trial, you have, I guess I'm just very hopeful, and I believe in our system, you have the same chance to win it as to lose it. And when I talk to some of my plaintiffs' attorneys friends, not the mills, I'm not talking about the mills, I'm talking about the guys that truly work in the transportation sector, can limit the number of cases that they take, that are strong advocates, that are smart guys. When I talk to them, they say, yeah, we're worried about getting zeroed out just as much as you're worried about getting hit with that crazy number. And like I said, I think it just creates this fear that the sky is falling, and people end up making decisions out of fear and not out of proper strategic, calm analysis. And I also think that sometimes it results in people settling too high because they're afraid of the alternative. I don't have a better term. I guess I tend to use outperformed or underperformed or runaway verdict or runaway settlement. And maybe that's because I'm a John Grisham guy and, love another movie reference, love John Cusack and Runaway Jury. I don't know the right term, but I really try to avoid when I talk to people saying nuclear verdict. And so I kind of sometimes land on that. Something can be outperformed or underperformed.
One more on this kind of fear situation that we have, and Steve kind of asked about this a little bit before, but just observing sort of the way that plaintiffs' attorneys advertise themselves often about these huge verdicts that maybe never paid out, but huge numbers on big billboards. And just looking for sort of your thoughts on how that drives that public opinion. And then maybe also, Pam, if we can just circle back to your point about the structural differences between the way that plaintiffs' attorneys get paid and the way that defense attorneys get paid, and how that sort of plays into this sort of puzzle that we're trying to piece together.
Well, Peter's right. The judicial hellholes are real. And there's definitely a correlation between how much attorneys are spending on attorney advertising and judicial hellholes. And it's an astronomical amount of money. The American Tort Reform Association tracks the judicial hellholes as well as tracks attorney advertising. And those billboards, again, are just another form of an anchor, right? It's just another form of an anchor. It normalizes numbers. People
Can you
don't
just
really
define
know the rest.
anchor for folks that maybe
Yeah,
don't know?
An anchor is really a terminology that comes from the marketing and sales thing. It's like it's a number. I'll use the Folgers, good to the last drop. You have this commercial where this son comes home from a leave from the military. He's in the kitchen. He's brewing a cup of coffee. His mother comes in. There's a heartwarming scene. They hug. Folgers, good to the last drop. That whole image and all of that, you can smell the coffee as you're watching the commercial. It all sinks in and it anchors in your mind this idea that Folgers coffee is good and it's good to the last drop. Or O.J. Simpson's trial, if the glove doesn't fit, you must acquit. It's just this concept of creating sort of a sentiment or a decision around something that's solid, and you anchor it to it. Now, plaintiffs' attorneys are using anchors in the context of making arguments around what would be the damage amount that they should be awarded. And so you hear the term jury anchoring, which is just sort of a build off. But billboards anchor people and they normalize numbers, and so you see this, oh, we won this case, we got this verdict, and the problem that we have in the attorney advertising space, which is a little bit different than lawsuit abuse reform, is that most advertising is both a function of state ethics rules for attorneys, could be federal law like Federal Trade Commission Act, Federal Communication and FCC, governed by the FCC, could be a state comparable type of, law that advertises what can be, on airways, commercials, advertising. So it's a lot harder to change advertising rules. One of the things that has been done, for example, in Texas, and it is a result of a particular billboard where the allusion was, it wasn't a trucking case. It was actually, as I recall, a sexual assault victim. And a particular plaintiff's attorney advertised, I won, let's say, $2 million. Well, the victim never saw any of the money. And it made him mad that this billboard was sort of telling his story, but not really telling his story. And so as a result, the rules were changed in Texas, and you have to sort of tell the rest of the story. You can't just say I won $2 million. You kind of have to say that you didn't collect $2 million if you didn't win $2 million. And so I think we need a little bit more of that, right? We need a little bit more of forcing
I'm hearing
them
in
to
my head
advertise
these like
the full
pharmacy
story.
commercials where they're like,
Yeah.
we won $200 million, recoup nothing.
Yeah,
Well,
exactly.
I mean, where
Exactly.
I live, the news, literally every evening, I'm watching the evening news, there is a plaintiff's attorney that's advertising every night, targeting truck companies. He says,
Right.
I'll win for you. They have deep pockets. Call me. Right.
Yeah.
It's crazy.
And we have to do a better job of advertising our wins. We really do have to
think
do
so.
a better job of advertising our wins and promoting ourselves.
We talked a little bit about the reptile theory, but what eats a reptile?
Mongoose.
Hey, a mongoose. You got it, Steve. Extra bonus point for you. What's the mongoose theory? Is this something that works, or how does that work?
So the mongoose theory is just like there's a bunch of people out there giving seminars on how to put the reptile theory in practice. There's a bunch of people out there giving seminars on how to put the mongoose theory into play, and that would be how to basically counter or diffuse the techniques taught in the reptile theory. I actually have never sat through one of those mongoose theory seminars, so I don't know, I don't really have a thought. I don't know these techniques or these efficiencies. Some people call it the reverse reptile. I'm reptiling the plaintiff, or I'm reptiling a co-defendant. And using their own techniques
using those
against
emotional
them.
tactics to paint the plaintiff as the bad guy.
Yeah, but what I can tell you is what I did when I was in-house, and I actually called it Deposition University. And Peter touched on something. So I had the luxury of working for trucking companies that the first $10 million was their money, and then they had excess layers above $10 million. So we had in-house legal, me. We had in-house claims examiners. We had our own rapid response center. That is the minority. A handful of those trucking companies fit that mold. Most people don't have in-house legal, don't have in-house claims that are monitoring, and they're relying on insurance adjusters or TPAs and maybe some type of fractionalized outside GC. But where I was headed with that is that for me, what I did is I identified the people at my company that I thought might be my company witnesses in a personal injury lawsuit. And I didn't wait for the actual notice of deposition. I trained them how to be deponents and put them through Deposition University, right? And so we took facts that existed in real life claims. I brought in defense attorneys, and I brought in my jury consultant. And we filmed them, and we mocked them, and we filmed them again, and we debriefed, and we mocked them, and we filmed them, and we debriefed, and we did it several times. And we made them do homework, and we made them take it seriously. Then fast forward, a lawsuit comes in the door. I get a notice of deposition for a company witness, and I say, okay, who from my list of people is going to fill this topic? And then we actually redo all of that, but in the context of the actual lawsuit to prep them for the deposition. That's essentially what the mongoose theory is, I think, right? Teaching somebody how to be a company witness. And Peter may feel differently than me about this, but I think that not every, and it impacts the smaller trucking companies that don't have the in-house staff, that don't have the resources, that maybe are working on deductible programs. Like they have $3 million in coverage, the first $1 million, $2 million in excess, and they have a $250,000 deductible. They may not be able to control their cases in the same manner I was, and they may not be able to put into place that type of program in-house.
This conversation could go on for forever. I'm really, really enjoying it. But we promised the people a discussion about the future and what we can do. And we talked about some of the tactics about, controlling the timeline and, having a good depot training program. But I think it's important to take away some of that chicken littleism to talk about what are some of the practical things that every trucking company could do to sort of protect themselves in certain ways. Some of that is what trucking companies can do, and some of that is also sort of what the industry is doing out there to fix the structural challenges out in the lawsuit world. So maybe we can talk just very briefly about the primary structural challenges that we see and what some of those states are doing to fix those, whether it's actual costs versus inflated costs and so on and so forth, and then move on to practical sort of carrier takeaways. So Pam, maybe you want to talk, I know you've been tracking all of the legislative happenings around the states. Maybe you can just talk to what some of the basic structural challenges are and then some of the fixes.
So, yeah, I mean, so obviously we want tort reform. Tort reform is very important. Lawsuit abuse reform, whatever term you want to call it. It's a long game. It requires the investment of not only, well, the typical time, talent, and treasure. You're going to need people, you're going to need money, and you're going to need stories that illustrate the problem. But one of the things there are two things that we have learned, the ATA has learned in our process since we launched our campaign. The first thing is we have truly come to appreciate the problem caused by state Republican legislators who are plaintiff trial attorneys. So back in the day, I was taught, and it worked for juries too. I was taught, you want Republicans on your jury because they're pro-business. You don't want Democrats on your jury. Same thing. Democrats are always anti-tort reform. Republicans are always pro-tort reform. Well, that has shifted because there are a number of plaintiff trial attorneys that identify as Republicans and run as Republicans in their states, and they are not supportive of tort reform. So you have to really be mindful of that sort of political problem and how you're going to navigate that conversation with them and get folks across the party lines to buy into tort reform. In addition, I think that at least in some states, we've witnessed that the win happens because there's a coalition of like-minded groups. So again, it's not just trucking companies in the personal injury and wrongful death space that are being hit with crazy numbers. So partnerships with our car manufacturers, partnerships with our retail and service, the Trader Joe's of the world, the Targets of the world, they're all facing, premises liability, slip and falls, have medical bills, just like our truck personal injury cases. So really forming coalitions with like-minded groups so that we're one voice talking together. And I think that the insurance industry is a valued partner to that conversation. But I think sometimes people get tired of hearing, oh, insurance premiums are going up. And what they really need to hear are the impacts of I'm a small business owner and I have 50 trucks and I want to expand to 75. And that would mean that I could hire 25 more drivers from my area, but I can't expand because the capital to get those 25 trucks is not something I can afford because I'm paying higher insurance premiums or whatever. But you have to drill it down to, I can't grow my business. I can't hire more people in your jurisdiction because of all of these increases in my operational costs. And those are the stories they want to hear, not my insurance premiums are going up. As I like to say, 50%
what can I do about
of
insurance premiums?
Yeah, I mean, 50% of my personal household income is coming from the insurance industry. But, I have a love-hate relationship with the insurance industry, to be perfectly honest.
Where do you both see technology helping, playing a role in some of these, defending against some of these outsized verdicts? Where can that help? Or in some cases, some carriers, when we talk to them, yes, it's great, but it also creates potentially more exposure and risk because now of all this information. What are you hearing, about that and how that's helping or potential issues to be concerned about?
Yeah, and it's a paradox, right? Because you want to adopt, people we talk to, they want to adopt safety technology, but that's always their first question. What do I put in my policy? What if I can't consume all the data? I think that's a great question. Sorry to jump on it, Steve.
Well, you're damned if you do and you're damned if you don't. So you're going to be damned if you don't. I don't know.
We're
Maybe
supposed
you
to
had
take
to
the
edit
fear
it.
out of this, Pam.
Yeah, I'm sorry. I dropped a major fear bomb, right? So you're gonna it's a no-win situation. If you don't adopt technology, you're gonna have a problem. And if you do adopt it and then don't, and Peter already said this, and you do adopt it, but you don't counsel your drivers with it, you don't use it as a learning tool, if you don't constantly improve upon yourself with the data, you've got a problem. So I always liked, when I was in trucking companies, I liked having the forward facing dash cams that we had, because then I was able to categorize the accident. Okay, this is a case where there's clear liability on our part, or this is a case where there's no liability on our part, or this is a case where we're going to have a dispute over liability. And it helped me frame my strategy. And, if it was a case of clear liability, then I knew that I had to be honest about that liability. And I was blessed to work for companies that if we were at fault, we admitted and acknowledged our fault. Now, that doesn't mean that we said that gives you a blank check for damages, but we acknowledged that our driver did something poorly that day, negligently that day, and you were injured as a result. Now we have to have a conversation around what that reasonably and fairly looks like. But I liked knowing that information.
Well, that's great, and it's also, helping those drivers not getting in crashes in the first place, right?
Which is all of our goal.
The goal, right?
Yeah, for sure. Awesome. Well, I said it already. I really believe this conversation could continue, and in fact, I'd love to reserve some time in the future to unpack a little bit more like what we as trucking companies can do. But for now, I'm going to have to say I think we're out of time. I know Steve's already late for a meeting, so I want to give everybody an opportunity to sort of say your last words, any additional advice you might have to carriers. I want to leave the group with just a little factoid. Pam had mentioned that that the politics around this are fluid, right? And that it's not Republican or Democrat anymore. And so, reading the Chamber of Commerce recent sort of update on their article, the top 4 states for nuclear verdicts: California, Florida, Georgia, and New York. So I think just those 4 really demonstrate the ping pong here of red versus blue and how it's sort of crossing everybody. And we all need to get out there and tell our good story and act first and control our own timeline and take back our industry. So I appreciate everybody's time, and I'll kick it to whomever for final words. Maybe we'll start with Peter, go to Pam, and Steve can take us home.
I agree, it takes a village. And in that, I want to put a plug in for any of the folks that are listening to this podcast that may be at a trucking company. If you are not currently a member of your state trucking association, they need your voice. They need your voice, they need your story, they need your time, they need your talent. And so, yes, I want you to be a member of the American Trucking Associations, but I also want you to be a member of your state trucking association. So please get involved there.
Amen.
And I'll just say, I'll just reiterate the data point that you mentioned, Pam, and this is relevant to all 3 of your comments, that it impacts every household in the country by $4,200. So let that sit for a minute. That's a big deal. So it's time to get if you're not already active, let's go get it. We've got some things we gotta deal with, and let's be active and be proactive about it. It's hurting all the country, and certainly trucking companies. So thanks both of you for your time today. We really appreciate it. It's been great conversation.
Yeah, thanks everybody. I have committed to not use the word nuclear verdict. I'm going to find some other snappy term. I'll let you guys
didn't
know.
like my outsized?
Outsized is good. It's
Outsized
pretty sanitary. I'm looking for something with a little joke in there, maybe a little barb at plaintiff's attorneys, but we'll come up with it. All right. Well, thanks everybody for joining again. Really appreciate your time, and hopefully we can catch up again soon.
Thank you.
Thanks all.
Thanks for listening to this episode of True North Truck Thought. If you enjoyed the topic today and want to tune in for future conversations here on the TTT Pod, make sure to follow us. Also, please don't hesitate to let us know which topics you want us to cover in future episodes. Drop us a line in the comments section or send us an email to transportationnews@truenorthcompanies.com. Thanks and have a safe day.